Okay, well, good afternoon. And thank you for joining me today for lunch with MIA, the MIA. My name is Kathleen Bahrain, and I serve as the Maryland Insurance Commissioner. The Maryland Insurance Administration is the state agency that regulates insurance sold in our state. Our team at the MIA is here to help you, both as consumers and as providers, when you have questions or concerns about insurance. The Lunch with MIA series is designed to tackle specific, timely issues of concern or interest to the public. And the topic for this session is a very important one, the Federal No Surprises Act, which went into full effect on January 1st this year, and what that means for you, specifically, as providers. The No Surprises Act places new responsibilities on providers to give notice to patients and limits circumstances when a provider may balance bill a patient. In some circumstances, and for some providers, balance billing may not be permitted at all. In other circumstances, it is permitted only when the patient has been given notice and consents to waive the balance billing protections. It also sets some new standards for how providers are paid. Due to our time constraints, this presentation today is going to focus on balance billing and notices to patients. Some states, including Maryland, have laws or regulations that protect patients against surprise billing. However, state laws generally don't apply to self-insured health plans and most people who get covered through their employer in self-insured health plans. That's where the Federal No Surprises Act comes in. It protects consumers in self-insured health plans and sets a standard for requirements that will apply to many more of your patients. Thank you again for joining us today, and now I'm going to turn the program over to Patty Dorn.
Thank you, Kathleen. Again, welcome to our event today for healthcare providers about the No Surprises Act. Some housekeeping rules. This event today is being recorded. The recording and the slides will be posted on our website in a few days. Please leave your phones and computers on mute for this event. If you're not presenting, if you could please keep your camera off. Due to the length of the presentation today, we will not have time to answer your questions during this event. However, you can place your questions in the chat box during the event, or you can email them to me at patricia.dorn@maryland.gov, and that email address should be appearing in the chat box, and I will make certain that you receive a response. Please, you need to include your email address or phone number so that we can respond to your question. You can also jot down the email addresses of the presenters today, and you can send your questions directly to them. Again, I want to remind everyone that this event is specifically designed to explain the No Surprises Act from the provider's side. If you're a consumer looking for consumer-related answers to the No Surprises Act, please see the recording on our website from our No Surprises event in February for consumers. Our presenters today are Mary Quay, the Associate Commissioner of Market Regulation and Professional Licensing from the Maryland Insurance Administration, and Kimberly Camerata, Assistant Attorney General at the Maryland Office of the Attorney General. You put up the slides, Joyce. So this is what Maryland healthcare providers need to know about the No Surprises Act's balance billing provisions. This presentation does not provide legal advice. You should discuss specific questions with your legal counsel or contact the Centers for Medicare and Medicaid Services. With that, welcome Mary Quay.
Thank you, Patty. Again, I am Mary Quay. I'm the Associate Commissioner for Market Regulation and Professional Licensing. But until recently, I was the Chief of Life and Health Complaints. And in that role, I heard quite a few complaints over the years from consumers about balance billing, particularly in emergencies when they felt they had no choice. And so the Federal No Surprises Act is putting rules in place that limit the amount that patients may be billed by healthcare providers, facilities, providers of air ambulance services, and these are for out-of-network services. We'll assume that if you're in network, you are accepting the carrier's allowed amount as payment in full, and the patient is getting the in-network cost sharing. The No Surprises Act also requires that patients be given certain notices and information about the costs for the services and the balance billing protections that apply. So the No Surprises Act was part of the Federal Consolidated Appropriations Act at the end of 2020, and it took effect on January 1st, 2022. And this will apply to most people who are covered in what we usually refer to as the commercial market. And that includes employment-based group health plans, and that is both for self-insured and fully insured business, individual or group health coverage that may be on or off the federal or state-based exchange, the federal employee health benefit plans, which are exempt from state law as well, and some other types of plans that are listed on the slide, including church plans and student health coverage. So where does it not apply? Well, these are government programs. So it's Medicare, Medicaid, the Indian Health Services, VA, and TRICARE. And so today, as Kathleen said, we will be focusing on the prohibitions on balance billing, the notice and consent requirements to have the patient waive balance billing protections and when that's permitted, the disclosure requirements, but we're going to not get into some of the other aspects of the No Surprises Act that affect providers, such as requirements around provider directories. And so I'm going to turn it over to Kim Camarata.
Sorry, good afternoon, everyone. As was mentioned earlier, I am Kim Camarata, Assistant Attorney General with the Maryland Attorney General's Office, but I'm also the Director of the Attorney General's Health Education and Advocacy Unit, and our unit assists consumers with their medical billing disputes and health insurance appeal-related issues. In doing that work, like Mary, we receive and have received many complaints over the years about surprise billing. And so this No Surprises Act, in very broad terms, protects consumers from being balance billed by out-of-network providers when they really have no control or ability to choose that provider. Balance billing, of course, as you know, is the billing the patient for the difference between the provider's charge and the amount the health plan pays, plus the patient's cost share amount, meaning their deductible, co-insurance, and co-payments. Next slide, please. The prohibitions on balance billing. Under the No Surprises Act, health plans are required to apply in-network cost sharing terms, and out-of-network providers or facilities are prohibited from balance billing patients for covered emergency services, for non-emergency services at in-network facilities, and for covered air ambulance services. The prohibitions on balance billing only apply to items or services that are covered by the consumer's health plan. And as the commissioner mentioned, these balance billing prohibitions became effective for services that are delivered in health plan years starting on or after January 1, 2022. There are some limited instances when patients can waive the No Surprises Act balance billing protections, and we will cover that later in the presentation. So what is the protection? When balance billing is banned by the No Surprises Act, providers cannot bill a patient an amount that exceeds their in-network cost share. And if a provider believes the amount was miscalculated by the plan, They cannot put the patient in the middle of that dispute. And I believe I'm now
Okay.
turning that back over to Mary.
Thank you, Kim. So prohibitions on balance billing by air ambulance services. About 6 or 7 years ago, the MIA had a public hearing on air ambulance services because we were getting a lot of complaints about very large balance bills by these services, or some of these services. And one thing that we learned in these complaints is that federal aviation law and airline deregulation preempted any state laws that tried to limit balance billing. And so since the No Surprises Act is a federal law, it can step in and protect patients from balance billing. And the type of services are indicated on the slide. And this applies when the air ambulance services are covered as part of the in-network coverage of an individual's health plan. And that will typically be in an emergency. And air ambulance service providers may not ask patients to waive their protections. The No Surprises Act does not, however, apply to ground ambulances. There are, however, some protections under Maryland law. All right, so emergency services. Physicians and other healthcare providers may not balance bill a patient for covered emergency services if they are out of network and providing services at an emergency facility. So, what is an emergency facility? Well, it is an emergency department of a hospital, regardless of the department, when providing post-stabilization services, and an independent freestanding emergency department. And that is defined by the federal law. And if you have questions about whether you are operating a facility that might be considered a freestanding emergency department, you might want to take that up with the Federal Department of Health and Human Services or talk to your attorney about the definition. Okay, emergency services are the services for an emergency medical condition. And different laws have slightly different definitions of emergency services, even if they start with a prudent layperson definition. And so for the No Surprises Act, they are services for when a person who has an average knowledge of health and medicine experiences a medical condition, and that might include a mental health or substance use disorder that is so severe that they believe they need immediate medical care, and that failing to get immediate medical care could result in their health, or if they're pregnant, the health of their unborn child, being in serious jeopardy, or result in serious impairment to bodily functions, or lead to serious dysfunction of any bodily organ or part. All right, so what services then fall under this? Because we're in an emergency facility, it's an emergency medical condition. So this applies to an appropriate medical screening exam that is within the capability of the emergency department, including ancillary services. So if the patient also needs imaging or laboratory services in order to evaluate whether an emergency medical condition exists, then those are included in this. It does not have to be in the emergency department. And further medical examination and treatment required to stabilize the individual. And again, this is regardless of the department of the hospital. And so if someone is taken from the emergency department for surgery, then the surgery is also covered by the No Surprises Act if it is to treat the emergency medical condition. So at what point is it no longer covered by the No Surprises Act? Well, post-stabilization services are considered emergency services, and the prohibition on balance billing generally applies. And those are services that are provided after the individual is stabilized, and that may be as part of an outpatient observation or an inpatient or outpatient stay, as long as it's related to the emergency visit, regardless of the department of the hospital. And this applies until the treating provider determines that the patient can travel safely to an available in-network facility using non-medical transport or non-emergency medical transport within a reasonable travel distance, taking into consideration the individual's medical condition, and the provider's determination is binding on the facility. So the treating provider and the hospital cannot make different determinations. It is up to the treating provider. And Kim will take the next group of slides.
And so at such time as the treating medical provider determines that that patient can be moved safely using non-medical transport and meets the other criteria Mary just outlined, under the No Surprises Act, once the patient meets that post-stabilization criteria, emergency facilities and some, but not all, out-of-network providers can seek a consumer's waiver of their balance billing protections. Again, we will discuss that shortly. But we would point out here that under Maryland law, consumers that are in Maryland regulated PPO or EPOs cannot have their balance billing protections waived by on-call or hospital-based physicians who accept an assignment of benefits. Similarly, Marylanders in Maryland regulated HMOs cannot be asked to waive their Maryland balance billing protections. So we'll switch now to non-emergency services. We've covered what happens with emergency services. The No Surprises Act law also protects consumers receiving covered services at an in-network hospital, hospital outpatient department, or ambulatory surgical center. When receiving those covered services at in-network facilities, out-of-network providers cannot balance bill patients for covered non-emergency services. And that includes services that will be on the next slide, such as equipment and devices, imaging, telemedicine, laboratory services, and pre and post-op services. The balance billing protections apply to those items and services, whether they physically happen within the in-network facility or elsewhere. So for example, if pathology is sent out to an outside lab and that outside lab is out of network, the balance billing protections would apply. Some services cannot be, the balance billing protections can be waived by consumers for some services, but they cannot be waived for ancillary services. So if a consumer is receiving an ancillary service in an in-network facility, the consumers cannot waive their balance billing protections for the services detailed on this slide, such as emergency medicine, anesthesiology, pathology, radiology, neonatology, if they're seen by a hospitalist, if they receive laboratory services. They also cannot waive their balance billing protections when services are provided by an out-of-network provider when there is no in-network provider who can provide the item or service at the in-network facility. Also, when items or services are provided at an in-network facility based on an urgent medical need in the course of the care delivery, the notice and consent exceptions to waive balance billing do not apply. The next two slides are charts that we took from the CMS website which was a webinar that CMS provided for providers. And they're a nice overview of when the notice and consent exception is permitted and is not permitted, both in the emergency services scenario and in the non-emergency services scenario. And they were included there for you for your information. And so we'll skip past those two charts and turn it back over to Mary.
Okay.
Oh, we won't turn it back to Mary yet. Sorry about that, Mary. I forgot this last slide. So we were talking about the notice and consent provision and when consumers can be asked to waive their balance billing protections. And again, as we indicated earlier, it's in very few scenarios where they can waive their balance billing protections. And when they do, the providers must use the CMS created notice and consent forms that are contained on the web link contained on this PowerPoint presentation. It's very detailed requirements covering what information must be provided, including, among other things, that the provider is out of network, and the provider must give a good faith estimate of the amounts that patients will be charged by the out of network provider. The requirements cover when that notice must be provided to be an effective notice and how that notice must be provided to be an effective notice. We urge you to carefully read and follow the instructions given by CMS when seeking notice and consent to waive balance billing protections. And now I'll turn it back over to Mary.
Thank you, Kim. All right, so the disclosure requirements. And these are disclosures in general of rights under the No Surprises Act. So healthcare providers and healthcare facilities prohibited from balance billing under the No Surprises Act, except for air ambulances, have to provide public written disclosures. The disclosures must include the prohibitions on balance billing for emergency or non-emergency services with which the provider or healthcare facility must comply. The disclosure has to include state laws governing balance billing and contact information for state or federal agencies that an individual can contact if they suspect that a provider or healthcare facility is violating the consumer protections under the No Surprises Act. So there are three ways that this has to be provided. One is a public sign posted prominently at the provider's physical location, posting on a public website, and a one-page notice provided directly to insured individuals that must be delivered in person or by email or mail based on the individual's preference. The one-page notice may use both sides of that single piece of paper and must use a font size of 12 points or larger. The latest that notice can be provided is the date and time when payment is requested. So when the patient is at the front desk paying the copayment, that may be the latest time for this notice to be provided. If payment isn't being requested from the patient, The notice must be provided no later than the date the claim is submitted to the health plan. So the Federal Department of Health and Human Services has issued a model disclosure notice. It is not mandatory, unlike the notice that Kim was talking about. And the web address to get that notice is on the slide. HEAU and MIA have also developed the required state-specific language. And our template with that language included is found on both agencies' websites. Okay, to shift gears from notices and disclosures. What does the patient have to pay? Kim referred to the fact that it is in-network cost sharing, but coinsurance and deductibles are typically based on an allowed amount. If you're in network, they're based on your contracted amount. So what applies now if you're out of network? Well, it is set by the recognized amount. And we're getting into very specific definitions at this point. But the recognized amount may be the all-payer model agreement. So in Maryland, that is the HSCRC rate for hospitals. A specified state law. So for example, if you were an anesthesiologist who is out of network and at an in-network ambulatory surgical center, and you have a patient who is an HMO member, that would probably be determined by section 19710.1 of the Health General article. And then the lesser of billed charges or the qualifying payment amount. So the qualifying payment amount is defined in regulation. And it's generally going to be the insurance company's median contracted rate for the item or service in the geographic area where the item or service was delivered. And that's based on the rate as of January 31st, 2019, indexed for inflation. And geographic area is another term that is defined by regulation. For air ambulance services, the all-payer model and the specified state law provisions do not apply. And then Kim will take it from here.
And so what Mary just covered was how the consumer's cost share will be calculated, which is a different formula than how the provider's reimbursement is calculated. So for determining the provider reimbursement, we first look to the all-payer model agreement. And again, if it is a Maryland regulated hospital, they will be paid based on the all-payer model agreement that the HSCRC and CMS have entered into. Again, like the patient's amount, if there is no all-payer model act, then we will look to state law. And as Mary indicated, for Maryland regulated HMO participants, or in instances where a PPO or EPO member is treated by an on-call or hospital-based physician that accepts an assignment of benefits, then the provider reimbursement is determined by state law. If the all-payer model agreement or a specified state law does not apply, then the carrier will make an initial payment to the provider that the provider is free to accept or reject, at which point the provider and the carrier can enter into a negotiation period about what that amount should be. Again, the consumer is out of the middle of this. This is a resolution that the provider and the carrier would enter into. After a 30 business day period of open negotiations between the provider and the health plan, if an amount cannot be determined, then the parties may enter into a federally administered independent dispute resolution process to determine the final payment. CMS has issued regulations about what the independent dispute resolution entity is supposed to use to determine what that final payment amount should be. A portion of those regulations were recently challenged and vacated by a Texas federal court judge, and CMS intends to offer new guidance and provide training in the near future about that formula. Determining the payment amounts, I've actually just spoken about these slides, so we can go ahead and skip to a little bit of information about where you can go for help or more information. As indicated earlier, the Maryland Insurance Administration can review decisions by health plans that are subject to Maryland law. And consumers now, if it is an MIA regulated plan, that should be printed on their ID cards. Specifically, the MIA can review the denial of all or part of a claim, whether the amount of payment complies with legal requirements, and consumer complaints about whether a claim was properly processed to permit balance billing. The Health Education Advocacy Unit, as mentioned earlier, assists consumers with medical billing disputes, including balance billing disputes. The HEAU can also help consumers, including providers seeking assistance on their patients' behalf, whose private health plans have denied coverage for all or part of a claim, or whose plans may have improperly processed the claims to permit balance billing. The HEAU will be mediating No Surprises Act complaints and will be enforcing the provider requirements under the No Surprises Act by referring cases to the office's Consumer Protection Division for enforcement. The next two slides are just a recap of information that we've covered, but on the second slide, we will point out again that this presentation is covering the No Surprises Act balance billing protections only. There are several other consumer protections contained in the No Surprises Act that the providers should become aware of. For example, providers are required to give good faith estimates in advance of scheduled services or upon request, currently for uninsured or self-pay individuals. Providers are also supposed to ensure continuity of care when their network status changes, and provide updated provider directories, and consumers are to be protected from relying on inaccurate provider directories. So we urge the providers to become educated on those balance billing requirements as well.
Well, thank you, Kim, and thank you to everyone who attended today.
Mary, and thank you, Kim. Our contact information is on this slide, the Maryland Insurance Administration. Our phone number, 800-492-6116, and our website, www.insurance.maryland.gov. If you want to email the email that you see here, the lhcomplaints.mia, go ahead and jot that down. That information is going to go to Mary. That said, you should also see my email, patricia.dorn@maryland.gov, in the chat. You can email me and I'll make sure that the question gets to the appropriate person, be it Mary or be it Kim. There's also information to get to Kim here, heau@oag.state.md.us, if you want to email directly to her. So that's the Health Education and Advocacy Unit, Consumer Protection, Office of the Attorney General. So again, I want to say thanks again to Mary and Kim today. More information about the No Surprises Act can be found at that website that you see there, and providers can email questions to CMS at the email address below. These slides are going to be posted on our website within the next couple of days. So look at them at insurance.maryland.gov. You should be able to download them directly from the website as well. The recording will be there as well. And so with that, we're going to put a survey in the chat if you're interested in giving us a little bit of feedback about the event today. As well, there's going to be a link if you want to sign up for information from us about events that we are having in the future. So you're going to see both of those links in the chat. So again, send those questions over. We will make sure that they get answered as soon as possible. And I just want to say thank you to everyone for attending this event today. I hope it was informative. And I hope to see you at one of our events in the future. So thanks again, Mary and Kim, and thanks everyone for attending. Have a nice day.